Good afternoon. This is William Lee, a Structured Finance Associate at Alston & Bird and a pro bono volunteer with the Asian American Bar Association of New York. First and foremost, we hope you remain well and safe during these unprecedented times. Thank you for tuning in to our COVID Relief Small Business Presentation Series, generously co-sponsored by the Asian American Bar Association of New York and Alston & Bird in honor of Asian Pacific American Heritage Month. Today's presentation will focus on the following question: what reorganization and bankruptcy options do the CARES Act and Bankruptcy Code offer small businesses? Before we continue, if you would like to access Abony's other COVID materials, including its resource pages on anti-Asian American violence and small business financial assistance, please copy and paste the first link. If you are a New York State small business owner and need direct assistance, please copy and paste the second link to fill out a clinic application with the Small Business Legal Relief Alliance. Throughout today's presentation, you may submit a question by using the Ask a Question box located on the left side of your screen. We will try to answer your questions during the program or follow up with you afterwards. This program is being recorded and will be available for playback immediately after it ends by using the same link you used to log in. All other questions can be directed to probono@abony.org. On the bottom left-hand side of your screen, you will also find event references that are available for you to download. Our panelists today will be William Howe, Restructuring and Bankruptcy Counsel at Alston & Bird, and co-chair of Abony's Commercial Bankruptcy and Restructuring Committee. Without further ado, I introduce you to William Howe.
Great. Thanks, Will. I thought we would start with just a little bit of a roadmap of the topics that we're going to be covering today during the webinar. So first we'll start with a little bit about the Coronavirus Aid, Relief, and Economic Security Act and the funding that's available. That's also otherwise known as the CARES Act. Then we'll really get into the crux of this presentation, which is about bankruptcy. What is bankruptcy? We'll cover some of the various types of bankruptcy proceedings that we often hear about. And then we'll focus in on what are called Chapter 11 reorganizations, as well as the recently passed Small Business Reorganization Act, which is something that really helps make Chapter 11 reorganizations more accessible to small businesses. All right, so first, with respect to the funding that's available under the CARES Act. I think a lot of this information is already out there. These programs have been live for a couple of months now, but we still thought it would be important to cover some of this in case people don't know or need some further information or some access to some resources. Generally, there are two programs that are available under the CARES Act. First, there's the Payroll Protection Program, otherwise known as the PPP. Then there's also the Economic Injury Disaster Loan Program. And the main difference between these two programs is that the PPP, so long as you use those funds within a specified requirements, which is actually for 75% of those funds to be utilized for payroll expenses. And if those funds are utilized within 8 weeks of disbursement, then you can apply to the government to have those funds and that loan converted into a grant, right? So essentially, that becomes a grant from the government. The Economic Injury Disaster Loan is just a straight government loan. It's a low-interest loan that's intended to provide relief and provide some help and liquidity for businesses dealing with the COVID-19 pandemic. So this slide has a little bit more information about the Payment Protection Program. I think the key takeaway here is that the principal loan amount, the amount that you can get from the government, is limited to 2.5 times your average monthly payroll based on 2019 statistics. And again, so long as you utilize them for the specified and authorized purposes, you can apply to get that loan forgiven. This slide provides you with some information about where to go and how to go about applying for a PPP loan. I think the most important point here is that, if your business already has a business banking relationship with the bank, it's best to check if that bank is providing and helping provide access to PPP loans, and try to go through that bank, because that really makes the process go a lot smoother for most businesses. And the current deadline for applying for a PPP loan is June 30, but we would keep an eye out because it looks like Congress is currently working on extending the relief that's available and broadening some of these packages. And also it's worth mentioning that there is still funds available under this PPP program. So even if you haven't applied yet, if you can still look into trying to get some of these funds at this time. For the EIDLs, this provides a little bit more information about eligibility. You can get a loan up to $2 million. It's a low interest rate loan, 3.75%. An important point here is if you try to get a loan for over $200,000, it will require a personal guarantee by the government, or for the government. Something worth noting here is that when you're filling out the application form for an EIDL, you can essentially check a box and try to get what's called an EIDL advance, which is an additional grant of up to $10,000. And that's pretty easy to do if you're already going through the EIDL process. This slide provides some information about how to apply, a link to where to apply. And I guess the important thing right now is because of the overwhelming response that they have gotten with respect to this program, applications are actually being limited right now to only agricultural businesses, which means businesses that are engaged in producing food and fiber, and also things like farmers. And again, currently the deadline is December 21, but the government is working on expanding and extending these packages, so I would keep an eye out for developments in that area. All right, so moving into kind of the heart of this presentation, let's start with what is bankruptcy? I think when most people think about bankruptcy, they think about for individuals, it's when the debt gets way too burdensome, they have an inability to pay, and they go through this process where they basically give up all their assets and then come out having been relieved of those pre-existing debts. And then for a business, most people think about, well, it's a business that can no longer operate, right? It needs to liquidate, it needs to wind down and close down. And similar to an individual, they give up all of their assets, those assets get sold, and whatever's left goes to pay its creditors. And those are two processes in bankruptcy, right? They are two very important processes. Bankruptcy is available for both individuals and for businesses, and it is available for this liquidation process for businesses, and also this fresh start ability for individuals. But the type of bankruptcy that we're going to really focus on today, and it's something that people don't really talk about that much, it's called reorganization. It's the ability to use the bankruptcy process to help you reduce your debt and try to renegotiate certain of your relationships with your business partners and your counterparties in order to come out of the process a stronger business that will be able to continue operations and to be able to thrive after you utilize the tools that are available to you in the bankruptcy process. And so, some of the types of bankruptcies that we normally hear about, Chapter 7. Chapter 7 is closer to what most people think about when they think about bankruptcy, right? It's for individuals and it's for businesses. A third party comes in, takes control of all the assets, sells everything off, and then liquidates it, and then takes those proceeds and distributes it to the creditors of either the individual or the business. Chapter 13 is something that some folks might have heard about as well. It's available only to individuals. It's where the individual tries to come up with a plan. They usually are wage earners, people with jobs, continuing income, and also property that they want to hold on to. So here, they come up with a plan. They say, I want to hold on to my house. I want to hold on to my car potentially, and I'll be able to utilize my future earnings to help pay down some of these debts, but at a reduced rate, at a rate that's a little bit more reasonable, something that I can actually achieve. That's what Chapter 13 is typically used for. Now, Chapter 11 is what we're going to focus on today, and this is for both individuals and businesses. And in this process, the debtor, which is the individual or business that files for bankruptcy, like a Chapter 13, they retain control, they hold on to their assets, they continue operating their business, and they work through the bankruptcy in order to figure out a way to reduce some of their debts and come to what's called a bankruptcy plan, right? Basically, a plan forward in order to pay down some of those debts and also be able to continue to operate and actually thrive after the bankruptcy process. Even though we're going to focus on reorganization today, I want to talk a little bit about liquidation, just the uses for it, and it does serve some important purposes, right? Some people might think, well, if going out of business, why go through this process? Why subject yourself to having to go to court and having to pay lawyers and do all this in order to close down my business, whereas I can just close the door and shut things down. For individual, first of all, it's pretty helpful because you get what's called a discharge, which is a legal determination that the debts that you had owed, that you had incurred, are no longer enforceable, meaning no one can come and collect them from you, right? No one can come and call you, sue you, or do anything to try to recover on those debts, as long as you have complied with the rules and have gone through the process adequately. And that's actually the same thing that happens for businesses here. So, particularly if you have a business where there may be some significant business disputes, or in a lot of instances where some of these disputes might start, flowing over onto, personal issues, and you need to get these to be finally determined. And so going through this court-supervised process provides, business owners, individuals, really with peace of mind, right? And because you get this official discharge, you get a court order that tells everyone out there that, look, you can no longer try to recover with respect to these debts because they've been resolved through this bankruptcy proceeding. So Chapter 11, what is it? We talked about, it's about reorganization, right? And the basis, the fundamental basis for Chapter 11 is this concept that a company is worth more when it continues to operate versus if it has to liquidate, right? So there's a policy in favor of helping businesses stay in business. And that policy is really set forth within Chapter 11 of the Bankruptcy Code, right? And what Chapter 11 does is it sets up a series of rules, creates a playing field for the company, which has incurred all this debt and is having difficulties meeting those obligations, and its creditors, right? All of whom want to get paid amounts that they're owed, or want the debtor to continue to provide services or provide goods. Okay, and how do you make it so that everyone can come to the table and figure out what's best for this company, so that this company can actually continue to operate, as opposed to having everybody pick at the company and forcing it into a liquidation scenario? So that's what Chapter 11 is intended to do. It's intended to create this this playing field so that everyone can come to the table and begin negotiating over the future of this business. So what are some of the tools that you get when you file under Chapter 11? The first one, and one that folks may have heard about, is the automatic stay. And this is a very powerful provision in the Bankruptcy Code. And it basically says that, on any debts that were incurred by the individual or by the business entity that's filing for bankruptcy, any efforts to try and collect upon that debt, right? Any lawsuits, phone calls, letters, things of that sort, all of that has to stop, right? And it stops automatically, right? It stops right upon the filing of the bankruptcy case, right? So the intention here is twofold. One is to be able to give the debtor some time, right? Relieve some of the pressure, right? We usually it's called a breathing spell that allows this entity some time to really think about what's going on versus having to deal with, all of these various creditors trying to collect debts that are owed to them. And second, it also prevents all these separate entities from, again, picking apart this debtor, right? It prevents everyone from, racing together, going to the courthouse, or starting lawsuits, or really taking actions that really are detrimental to all that are involved. The example that most people probably are most familiar with is mortgage foreclosure, right? If you have a secured lender, you have a mortgage, say on a piece of property, the secured lender has gone through a lawsuit, it is, gotten judgment, is about to execute upon its foreclosure upon that property and take control of it. So long as you file for bankruptcy, even 1 minute before the foreclosure has been executed, that foreclosure has stayed, right? And it's not allowed to proceed. So it's a very, very powerful provision of Chapter 11. And actually, all the bankruptcy code, all the other chapters get the benefit of this as well. Second major benefit is the ability to reject burdensome contracts, right? And so once you get this automatic stay, you get some time to kind of think about, what are good contracts that you might have and what are bad contracts that you might have. And you get to look through them and get the ability to essentially cancel those contracts or get out from under those contracts. Let's take an example here. Let's say we have a business that manufactures T-shirts, and that his customer entered into a long-term, say a 10-year contract to manufacture T-shirts at $1 a T-shirt, right? Let's say, initially it was costing them maybe 90 cents to make that T-shirt, and they thought, well, look, we're making a little bit of money. Maybe this customer, hopefully, will see that we do good work. They'll want to, do some more business with us, and they'll be able to up the price, and we'll start making a little bit more money after that. Or we can show, other customers out there that we're doing good work and let us get our foot in the door. Let's say, a year or two passes and overhead starts going up, rent starts going up, labor costs start going up, and now it's costing this company, say, $1.50 in order to make that T-shirt, right? So getting paid $1, costing that company, $1.50 on every T-shirt, losing 50 cents on every T-shirt that they're making. So what would happen outside of bankruptcy? You can go to your customer and say, look, we can't do this anymore. Can you start paying me a little bit more? That customer says, well, look, you locked yourself into a 10-year contract with me, and if you don't perform, you end up facing a lawsuit, right? And that lawsuit can sue for damages for up to 8 years of T-shirts that should have been produced at $1 a piece. And just facing that and dealing with that and all the pressure of that, and if that lawsuit actually gets filed, that creates, especially for a small business, a huge drag on that business and its ability to go on and perform, right? In bankruptcy, you get to kind of short-circuit all of that, right? You get to do that analysis with respect to all the various contracts that you have and make that determination. And rather than that customer having the ability just to drag you into court, and then a different customer who might also have a bad contract with you and drag you into court, they're all forced to come to the table in the bankruptcy court in order to negotiate with you with respect to how to proceed with respect to your contract, right? Because you would have the ability to just cut it off, and when they cut it off, they do get damages and they get a claim, but that claim gets paid in bankruptcy dollars, meaning they may not get the full amount of damages. They may get maybe 10%, they may get 5%, they may get less, right? And when faced with that prospect, the the customer may be much more willing to renegotiate terms of that contract. And that's really a really good example of what the bankruptcy process is supposed to try to do. It's supposed to create different leverage points so that you can enter into these negotiations, and all of these business relationships can try to come together in order to figure out a way so that they can move forward in a reasonable manner after the bankruptcy. Another ability, which we'll talk a little bit more about later on, is the ability to reduce and eliminate debt, which is to compromise debt. It really depends on the type of debt we're talking about, but suffice to say, you're able, just like with those, with the customer and their contract claims that they might have, if you were to cancel that contract, they couldn't be forced through the bankruptcy process to take much less money than they would be entitled to otherwise. Something else that's important that may not be as prevalent in a small business, but is still worth mentioning, is something called free and clear sales. So outside of bankruptcy, normally when you sell a piece of property, let's say you have a property with a mortgage on it, you either have to pay off that mortgage when you sell it, or the purchaser has to take that property subject to that mortgage. Okay, so, and obviously, if that purchaser has to take subject to that mortgage, they're going to be willing to pay much less for that property because it will, they'll be liable for the amounts that are owed on that mortgage. In bankruptcy, you're able to cut that mortgage off, right? You can put that mortgage to the side and say, look, I can sell you this property as if there's no mortgage on it. What are you willing to pay? And obviously, the amount that they'll be willing to pay is going to be a lot more, right, than if it were encumbered. And this all goes to trying to maximize the value of the assets that the debtor entity or the bankrupt entity is holding. So with all these tools, right, these ways to try to reconfigure your debt, why haven't more small businesses actually utilized Chapter 11? Right. Well, there are a number of negatives, and the biggest one is expense. Chapter 11 is an expensive process. You have to pay for lawyers. Lawyers are not cheap. I'm a lawyer myself. I know the services when it comes to Chapter 11 work can be quite expensive. Financial advisors, because a lot of the time, debtors, you need help with projections, you need help figuring out the financial issues that are at play. And then something that's really important here is it's called the creditors committee. So upon the filing of a Chapter 11 case, your what are called general unsecured creditors, which are creditors that do not have a lien or do not hold liens on the company's property, they're allowed to organize and form a committee, and it automatically gets appointed upon a Chapter 11 filing. And that committee gets to essentially represent the interests of all other general unsecured creditors, and they get a say in the bankruptcy proceeding, right? So whatever the debtor is trying to do, this committee, gets to weigh in on it. So let's say the debtor says, oh, I want to sell one of my properties and try to utilize those funds to, build some more machines and work on this other part of my business. The creditors committee can take a look at it and say, look, we don't agree. They can fight you on it. And, they get that voice in a bankruptcy case. And what's more, they get to hire lawyers themselves. Sometimes they get to hire their own financial advisors. Sometimes they even get to hire their own investment bankers, depending on the case. And all of those professional expenses, all of those expenses are paid for by the debtor as well, right? So file for Chapter 11, you have to pay for your own lawyers, your own financial advisors, and then you have to pay for your creditors' lawyers, financial advisors to scrutinize the things that you're actually trying to do. Then there's U.S. trustee fees. It's a good time to talk a little bit about U.S. trustee. It's a part of the Department of Justice. It's an entity that appears in all bankruptcy cases, and they're essentially a watchdog of the bankruptcy system. Sometimes you'll hear about them. They kind of look over mainly procedural issues, but keep an eye to make sure that things are running smoothly through the bankruptcy process. And they also get to collect certain fees depending on the size of the cases and the disbursements that are being made in the Chapter 11 case. And these fees, they're thousands to tens of thousands, sometimes hundreds of thousands, and they start adding up, and they're paid every quarter in a bankruptcy case. And there are other kind of filing fees that come along with just utilizing the court system. And then we'll talk about this more in depth, but there's just a lot of work, right? So there's just a lot of expenses. There's a lot of things that need to be figured out and done through a Chapter 11 process. Another big negative, especially when it comes to small businesses for Chapter 11, has been what's called the absolute priority rule. So this is a rule that in a regular Chapter 11, you basically break down your creditors into three major buckets. You have your secured creditors, you have those that have liens, debt that are secured by liens. Then you have, like we talked about, the general unsecured creditors, folks that are represented by that creditors committee. And then you have the equity interests, which are the owners, right? The people who, the business owners themselves, the people who own the business. And what the absolute priority rule says is that in any plan, right, which is what you're trying to get to, the end result in a Chapter 11, in any plan, before each successive level of debt can get paid, the preceding level needs to be paid in full. So before a general unsecured creditor can receive 1 penny on their claims, secured creditors need to be paid in full. And most importantly, for business owners, right, small business owners, before they can retain their interests, right, before they can continue owning this business after the bankruptcy, they have to be able to pay all general unsecured creditors in full. So obviously that is a big deterrent, right? Most businesses, they're filing for bankruptcy because they're unable to pay their debts as they come due. They're not able to pay their general unsecured creditors in full, right? And they're looking for ways to renegotiate those debts. But if there's a likelihood that if you're unable to pay them, you can't retain ownership through the bankruptcy process, then why go ahead and file for bankruptcy, right? So that has been something that's been a big hurdle for small businesses in filing for Chapter 11. And there's also, of course, reputational risk because, like we said earlier, a lot of people, when they think about bankruptcy, they think about it as liquidation, think about a business that's going out of business, and so they're less likely to want to work with you, and customers may start withdrawing and all of that. And then there's also the risk that you spend all this money, you go through the process, and you ultimately fail at utilizing these tools to try to restructure your debt and come out a more healthy company, and you end up going through a liquidation anyways. So with all those negatives, how can Chapter 11 actually help small businesses? So these were the kind of issues that Congress had thought about over the last few years, and luckily right before the COVID-19 pandemic really started taking hold in the United States, in mid-February of this year, what's called the Small Business Reorganization Act became effective, right? And the goal of the Small Business Reorganization Act is to try to make it a lot easier for small businesses to access Chapter 11, to utilize the tools that have been available to larger corporations out there, and try to utilize those tools in order to reorganize and restructure. So, what were the changes under the Small Business Reorganization Act? First of all, it's now a much less expensive procedure. One of the big expenses that we talked about earlier, the creditors committee, right? Having to pay for your creditors, professionals, that's been done away with. So in a small business Chapter 11, right, under these amendments, there's no longer an automatic creditors committee. There's also no longer any U.S. trustee fees, right, which are thousands to tens of thousands, hundreds of thousands that might add up over the course of a case. And then there's also no requirement of a disclosure statement. And this is a document in a normal Chapter 11 that is, one step before you get to your bankruptcy plan. And essentially, this really goes to trying to condense the whole procedure and make the Chapter 11 process a lot faster and more streamlined for small businesses, right? Normally in a Chapter 11, first you have to seek approval of a disclosure statement, which is something that goes out and describes your plan and goes out to all your creditors. That can take 30, 45 days. And then another 30 and 45 days after that is when you can then take your plan and go to the bankruptcy court and try to get your plan actually approved. Right, so now they've cut out that whole step and cut out the, frankly, the expense of producing that document, which can be fairly substantial as well. And a big thing, right? We just talked about the absolute priority rule and the inability for equity interests to retain ownership if they don't pay general unsecured creditors in full. These new amendments have done away with that as well, right? So now you can get a plan approved by a bankruptcy court, right, where general unsecured creditors aren't being paid in full, while the prior owners can retain their ownership interests after bankruptcy. And so that's huge. So how do you qualify, right? How do you qualify as a small business debtor? And sometimes I'll refer to as a subchapter 5 debtor, which is just another name that we've given to these small business cases. So it's available to both individuals and business entities, right? And essentially, you just have to have debt that is below a certain threshold, okay? Originally, when the SBRA was first enacted, it was $2.725 million, right? So as long as you had debts that were less than that amount, you can utilize the small business provisions of the Chapter 11 Bankruptcy Code. Under the CARES Act, they actually raised that to try to make these new provisions, more widely available for small businesses, and they've raised that limit up to $7.5 million, right? So now, as long as you have less than $7.5 million, and and at least half of that has to be business-related debt. So as long as you have less than that amount of business-related debt, you can qualify under these new amendments. And so, what does that process look like? This is just a little chart. We're going to actually, walk through some of this because I think it's helpful for folks to, if you're really going to consider this as an option, to have a good sense of, what that process looks like, what the timing looks like, and what are the other things that you might have to do in order to, get through a Chapter 11 successfully as a small business. So first, you have to speak to a lawyer. This is a court-supervised process. You have to appear before the bankruptcy court. You have to submit things formally to the bankruptcy court, and you really do need legal guidance in going through this process. And that lawyer will help you, prepare and file the initial document that starts a bankruptcy case, which is called a bankruptcy petition. It costs about $1,700. Some of the information that you'll need in order to put together that initial document are, a list of your creditors, a list of equity holders, list of the, the owners of the business. The Small Business Reorganization Act also requires a list of your balance sheet, a cash flow statement, statement of operations, which is otherwise known as a P&L, and also your latest copy of your latest tax return that you've been filed. Other initial things that need to be filed very early on in the case. In some jurisdictions, you're required to file this thing called the initial affidavit. Typically, it'll be the small business owner that files it. It's essentially swearing to certain assets, whether the assets that are held by the business, information regarding claims, information pending litigation, and the identity of management. Then another thing that might come up very early in the case is something called dealing with use of cash collateral. So, when we're talking about this framework that Chapter 11 sets up, one of the things that they set up on this playing field is with respect to cash collateral. Cash collateral is really just, if you had a secured creditor, let's say they had a lien on a bank account and the cash in that account, or another example would be if a secured creditor had a lien on, products that you produce, as well as proceeds of those products. So when you sell that product, the cash that you get for that product, they have a lien on that. That would all be their, cash collateral that secures their claim. In bankruptcy, once you file a petition, you're actually not allowed to utilize cash that has a lien on it, right, or cash collateral of a secured lender. You can only utilize it if you get consent from that secured lender or if the bankruptcy court allows you to do that. So that means that you either have to go negotiate with your secured creditor, get their agreement, or you have to file a motion with the bankruptcy court to get the bankruptcy court to approve your use of cash collateral. So that's something that, if you have secured claims and you have cash collateral issues, that's something you're obviously going to need to deal with early on in the case, because you'll want to be able to utilize cash to fund operations as you go through the process. Professional employment, in a bankruptcy, you have to formally engage your lawyers and other advisors, and so those applications need to be filed early on as well. And then this is an important feature that's unique to small business bankruptcies, which is the appointment of a subchapter 5 trustee. And so this is a position that was created just for the SBRA and for these small business bankruptcy proceedings. And these are folks that are supposed to help, essentially advise and help the debtor, work through its financial issues, right? It's supposed to help them look at, the business plan, help them determine, a good path forward for the business, help them analyze that, the cash flows, balance sheets, and other parts of their finances, and also help them, deal with their creditors, help them negotiate with them, and help them really, with some knowledge of both, the financial aspects and also, the construct of the bankruptcy law, to help them come together and get a plan together in a more efficient manner. And this is really big because, otherwise, you would have to engage other advisors that would have to do this for you. And some small business might still do that, but having this kind of separate entity that's provided through the bankruptcy process in place is really intended to kind of smooth out those hurdles for a small business owner. And in connection with that, you're required to have an initial meeting with that subchapter 5 trustee early on in the bankruptcy case to help get that process started. Then there are other kind of financial reporting requirements during the bankruptcy case. One of the landmarks or trademarks of a bankruptcy filing is financial disclosure and financial transparency, right? So debtors, businesses, they're required to be to make sure that you're not hiding things, right? Because you're trying to bring everyone to the table, you're trying to have an honest conversation about your finances. So you have to make all of that information known, right, to all of your creditors, to the subchapter 5 trustee, to the court, so they can properly analyze the situation and determine whether the plan that you're putting forward is viable, right? So you have to file things like a scheduled statement, which is a list of your creditors, your assets, again, some of your list of your contracts, your leases. There's also other additional monthly reporting, which is still fairly basic information about your income, your debts, things like whether you're keeping up with your taxes. And those are other documents that need to be prepared and filed with the bankruptcy court. And then there are other, this is a court supervised process, so there are other court appearances that a small business is burdened with through the bankruptcy process as well. Something called a 341 meeting. That's something that usually takes place, somewhere close to the bankruptcy court. Is usually scheduled for 30 or 45 days, after the bankruptcy filing, and it's really for the debtor. And you appear with your lawyer, and your creditors can come and ask questions about finances or your business plan, and usually the United States trustee is there as well. And then for a small business bankruptcy in particular, there's a requirement for a status conference with the court within 60 days. And the purpose of this is for the court to also weigh in and get a sense of what's going on, what this business is trying to do, what its plan is in order to try to get through this bankruptcy process. Really keeping tabs to make sure that progress is being made in negotiating with creditors. And 14 days before that hearing, a report actually has to be filed with the bankruptcy court, kind of detailing some of those efforts. And so, the rest of the time that you're spending inside bankruptcy, the time and the effort is going towards, working to get to a viable business plan, right? And utilizing some of the tools we talked about earlier, right? Reviewing all your contracts, right? Figuring out whether you're going to reject burdensome contracts, going to those customers or your other creditors and try to negotiate with them with respect to, the scope of those contracts or scope of the debt. Think about, whether or not you want to sell off portions of your business in order to consolidate around something that's a little bit more profitable, right? And you're doing this with the help of the Subchapter 5 trustee. You're in negotiations, and you're really trying to envision, what this business can look like by reducing, the debt burden, and then what the cash flows and the income will look like, after you exit from the bankruptcy process. So the whole point here, right, is to get yourself to the bankruptcy plan, right? And under a small business case, they've made the deadline for filing a bankruptcy plan 90 days from when you first commenced the bankruptcy. That deadline is something that can be extended, but it's also notable that there's actually no deadline for getting that plan confirmed or approved by the bankruptcy court after you file. I think all these timing issues are actually pretty important right now because the timing is, one of the important drivers, we think, for small businesses in utilizing Chapter 11 in response to the COVID-19 pandemic, right? One of the difficulties that businesses are having right now is, trying to figure out what their cash flows are going to look like in the future, right? Trying to figure out what this business will look like when things, start hopefully getting back to normal, right? And because of all this uncertainty with respect to the economy, where things are going, what it's going to look like when stay-at-home orders are lifted, there's a very wide scope of views between companies, debtors, and their creditors with respect to trying to forecast and project all of that, right? So trying to negotiate all of this and trying to come to some sort of consensus outside the bankruptcy process is extremely difficult right now, right? Which is why you're seeing a lot of these companies, large corporations right now, utilizing bankruptcy to try to buy some time and try to bridge that gap, get to a point where they might be able to have a little bit more certainty about what the future holds, right? And so that's the same reason why it could be useful for a small business, right? Even the 90-day filing deadline currently under the Small Business Reorganization Act, those 90 days, if you file bankruptcy now, that can provide a lot of information, right? Think about, knowing what you might have a lot more information about what the economy will look like 90 days from now, right? You have a much better sense of what your income might look like, what your business might be looking like 90 days from now. And it's also, like I said, that time period can be extendable, right? And you might be able to stay even longer in bankruptcy. You might, utilize some of these tools to, drag it out a little bit more to try to get more certainty, depending on the case, depending on your circumstances. But that option, right, is available. And that's kind of the takeaway here. That's important to know. All right. So, since the whole point here is to get ultimately to a bankruptcy plan, talk quickly about what are the requirements for a bankruptcy plan as a small business debtor. There's some procedural things. You have to include a brief history of the operations, a liquidation analysis, which is essentially showing what the value of the assets would be if you just liquidated everything. You need to kind of show that, by continuing business, you'll actually create more value. Projections, right, and this is going to be an important part here, is projecting what the business will look like, what the income will look like, taking into account the debt payments that you're proposing under the plan. And again, there's various forms now that are available for these small business plans out there, which will kind of cut down the costs connected with putting together such a plan. So what can you actually do in your bankruptcy plan? Well, you have to deal, right? You have to deal with your creditors, right? And there's various classes of creditors that we'll talk about here. First is administrative expenses. Those are essentially things that you incur during the bankruptcy case, right? Things like paying your lawyers. Then there's priority claims. There are certain specified types of claims, like some wages of employees, some tax claims that are afforded certain priorities that you have to deal with. Then you have your secured claims, general unsecured claims, and equity interest as well. For secured creditors, how you are allowed to treat them, right, under a bankruptcy plan, really depends upon the value of their collateral, right? It depends on if they're oversecured, undersecured, but generally what you can do is you can try to stretch out payments over time, and you can try to adjust the interest rate and try to lower the burden on the company going forward by negotiating over those prospects. What can you do with respect to unsecured creditors? Well, this is probably going to be the biggest source of friction when it comes to a small business bankruptcy plan. And this is, it's a provision that's different from other provisions in bankruptcy court. And it says that, in a small business plan, all of the projected disposable income, right, of this business in the next 3 to 5 year period needs to be utilized towards paying down their general unsecured creditors, right? And there's a definition for disposable income, but that definition is actually quite broad, right? There's some certain things that they mandate that needs to be paid, such as domestic support obligations, things necessary for the quote-unquote maintenance of the debtor, and also this broad provision that says things necessary for the payment of expenditures for the continuation or preservation or operation of the business, right? I don't think you have to be a lawyer to understand that people are probably going to fight over what those words mean, right? Because if you project disposable income to be very high, then you're going to pay a lot of your future income to paying down your creditors, right? So most debtors, most businesses are going to be incentivized to try and lower that amount. And creditors, on the other hand, are going to fight over what's necessary, right? And say that you should be paying a much higher percentage of your future income towards our debts. And so all of this is really uncertain because, like I said, these provisions have only been in place for a little over 90 days now. There haven't been many cases that have actually gone through a plan confirmation process yet. So courts haven't really spoken on this. But in my view, it'll likely be a lot of input from the sub-Chapter 5 trustees. I think, they'll, have a lot of say in how these provisions get interpreted. I think their views on what is necessary and what's reasonable in projecting future income and disposable income under a bankruptcy plan, I think those will be important, that will provide important guidance to courts as they try to deal with these issues. And then again, in one of these plans, you can, in a small business bankruptcy plan, equity interests, the owners, they can actually hold on to their interests. All right, so what happens, after bankruptcy, right? So after you get your plan proposed, you get your plan approved by the bankruptcy court, then what happens? Well, you've proposed a plan, so you have to make payments on the plan. And there's some difference between whether or not the plan ended up being a consensual plan, meaning most or all of your creditors agreed to that plan, and that actually goes through a voting process, right? Once you come up with the plan, you propose it, you'll put it out to a vote of your creditors. If it's consensual, then the business entity just makes those payments directly. If it's non-consensual, meaning people have not agreed to it or have objected to it, then those payments are made to the trustee, and then the trustee then disperses those payments out to those creditors in accordance with the plan that was proposed. And then there's a discharge, for a small business bankruptcy debtor. So discharge, we touched upon it a little bit earlier. A discharge is a legal determination that you're no longer liable for these debts, right? So again, there's a difference depending on whether it's consensual or non-consensual. If it's a consensual plan, right upon approval or confirmation by the bankruptcy court of this plan, you automatically get a discharge. If it's non-consensual, meaning there have been objections to it, then you have to go through the whole process of making all those payments, which can be between 3 to 5 years. And then once all those payments are completed, then you receive a discharge of those prior debts. Okay, so that takes me to the end of the presentation, but I want to kind of recap a little bit about kind of the tools here and the importance of the Small Business Reorganization Act and the recent amendments. It really does provide an entry point for small businesses to utilize these really expansive tools that have been available to larger companies for many years, right? And it was really couldn't have been better timing, right? Because being able to get that breathing spell, being able to get some time to see what's going to happen, right, in this economy, and buying that time through a bankruptcy process, it's something that just was not really available, if not for these amendments. So, now that they're here, it's something that folks should consider, take a look at, try to get information on, and then later on at the end of this, we'll have some slides where we have some links for places where you can get some additional resources and additional information about this and other aspects of the Small Business Reorganization Act, as well as resources to reach out for, try to get some legal help. And a lot of firms out there are providing legal help in this arena on a pro bono basis. So look out for that as well.
Thank you very much, Will Howe. I'm sorry, we just had some questions from the audience. I'm not sure if we can address them right now or if you wanted to wait.
Yeah, no, you can go ahead.
Great. So we have very good questions from our audience members. First question, does a business have to pay rent while in Chapter 11?
Yes. Okay. So the short answer to this is yes. It's what is called an administrative expense that we talked a little bit about earlier. So, if you're using the property that you're renting, right, and you're using it for your business during the bankruptcy case, yes, you do need to perform those obligations, meaning you do need to pay your rent, right? But there is a timing issue here. The Bankruptcy Code doesn't require you actually to pay your administrative expenses, promptly. It only says you have to pay them upon confirmation of a plan. And actually, in a small business case, you're allowed to pay administrative expenses through a plan, meaning you can pay them over time. So you don't have to come up with the cash upon approval of your bankruptcy plan. Now, when it comes to real property and leases, so rental payments, you have a 60-day window within which to kind of make a decision. And, after 60 days, you will have to come up and start paying rent presently. But before you get to that 60-day window, you can kind of have a little bit of a breathing spell, defer payment on that rent until a later time. And this is actually pretty important for some of these larger bankruptcies out there, especially retail, where rental obligations are a huge part of their expense. For example, J. Crew, they just got approval, not to pay rent for the first couple of months of their bankruptcy.
Thank you very much, William Howe. It was very helpful. Next question. Who sits on the creditors committee? Would this include every creditor?
No. So it's usually the top. They take a list of your top 20 or so creditors, and then the creditors are asked if they have any interest in serving on the committee. And then it's the U.S. trustee actually who chooses members for the committee. It's usually something like 3, 5, 7 members that sit on the committee. and they're supposed to work together, again, to represent the interests of all the general unsecured creditors.
Great. Thank you very much for your explanation, William Howe. The next question from our audience members is, how have the definitions of a secured creditor and unsecured creditor changed under the SBRA?
So the definitions haven't changed, but the treatment or the required treatment of those types of creditors has changed. Right? We went over, with respect to, unsecured creditors, you have to meet that disposable income test, and your treatment of those types of creditors needs to be at a minimum, right? Payment of all of your quote unquote disposable income over the next between 3 to 5 year period, right? For secured creditors, the treatment is actually it's the same, but there's some slight differences with respect to ability to say modify rights on residences. There's a new provision for small business bankruptcies there, but generally the treatment of secured creditors are the same under the under regular Chapter 11 and under the small business provisions.
Great. Thank you very much, William Howe. Next question from our audience. If there is no absolute priority rule, what happens to the rights of the creditors? Are such rights different between secured and unsecured creditors?
Let me think about that. Yes, I mean, so between secured creditors and unsecured creditors, that treatment requirement is still the same. So I guess I would say the absolute priority rule still applies with vis-a-vis secured and unsecured creditors. It's just they've eliminated the requirement for equity, the absolute priority rule with respect to equity, so that ownership interests can be retained, notwithstanding the fact that you're not paying general unsecured creditors or secured creditors, for that matter, in full.
Thank you very much, William Howe. We just have 2 more questions from our audience members. The first question is, who appoints the trustee? Is it the bankruptcy court? Who pays for the work of the trustee? I think you may have already answered the last question.
Yeah. So if we're talking about the sub-Chapter 5 trustee, that's actually a pretty interesting question. It may depend a little bit by jurisdiction, but here in New York, there's a panel. So the U.S. trustee, which is that arm of the Department of Justice, they create a panel of sub-Chapter 5 trustees that they can pick from or appoint from for each of these sub-Chapter 5 small business cases, right? Basically, you have a group of people who are available to serve as trustees. That's similar to like Chapter 7. For Chapter 7, there's also a panel of trustees available out there. So the bankruptcy court itself doesn't pick them, though in some other jurisdictions that may be the case. It's kind of unclear. I think the rules don't really specify how they get appointed. Who pays for the work of the trustee? So it will be paid out of the bankruptcy plan most likely. And so this has been something that people are looking at and trying to figure out exactly how this is all going to work, because these recent amendments didn't spell it out precisely. It does spell out one possibility, which is payment through a percentage of the plan distributions, right? So they would take a cut of future the future income and the stream of payments that are made under the bankruptcy plan. So that's one possibility. But there are other potential circumstances where the trustee won't be around, right, to disperse things and will no longer be involved in the case. And there's still a kind of an open question of how the trustee will get compensated in that instance. And so we're kind of looking to see how that gets done. But it'll likely be some payment through the plan process that compensates the trustee for his or her work on the case.
Great. Thank you very much, William Howe. And our last question from our audience. It's actually a very similar question. The question is, who are these trustees? Like, can you provide any examples from your experiences Are there any other requirements to be a trustee?
Yeah, so Subchapter 5 trustees, they've generally been kind of more on the financial side, folks that are either restructuring, financial professionals, financial advisor types, folks that serve as, who have in the past served as, like restructuring officers for companies. So, most of the ones that are on the panel for, Southern District of New York, they have, deep experience helping turn around companies. And so that's, I think, and I haven't really looked for many of the other jurisdictions, but my guess is that it will be a similar type of background will be what the U.S. trustee is looking for in order to kind of populate these trustee panels.
Thank you very much, William Howe. One last question actually just trickled in. So in relation to small businesses, obviously, the interests of a small business would be to take care of its employees. The question is, what happens to the debt that are wages of the workers, these employees? Once they file bankruptcy, what happens to debt in terms of making sure that these workers and employees are adequately compensated?
Mm-hmm. So under the Bankruptcy Code, one of the priority claims are, certain amounts of, there's a statutory amount for wage claims, right? And so, those will have to be paid, either, right upon confirmation or, shortly, through the plan. Usually, they have to be paid upon confirmation. But, what actually happens in a lot of bankruptcy cases is that you seek to continue regular payments to your employees, right? Because if you're really trying to continue operations, and when you plan your bankruptcy, you'll typically file it right after you've made your last payroll, right? So that you're not, in between payroll periods. But if you are, you may also seek bankruptcy court approval to just, continue paying, continue your normal payroll procedures, so that you're essentially, paying them off and keeping them current during the bankruptcy case. I mean, obviously, these are kind of for the, if labor is a big issue for the company, then, they may try to do different things, right? But those are the options available to a company, right? They can utilize these options, and if, keeping their employees happy while they're in the bankruptcy process is important for that type of business, then, they can seek to make sure they're paid and current, very early on in the case, or structure the timing of their bankruptcy to ensure that they're never behind on any payments.
Thank you very much, William Howe, for answering our audience's questions, your time, the thorough presentation, and just giving back to our community. Again, if you would like to download today's slides, please click on the Event References tab on the bottom left-hand side of your screen. All other questions can be directed to probono@abney.org, and all other resources can be found on this last resources slide that we will show in 1 second, that we have compiled for our audience here today. We hope you enjoyed today's presentation, and please remain safe. Thank you very much.